Thank you everyone for being here. I do have a sty on my eye, so I apologize if you notice my eye is a little injured, but shouldn't affect the performance of the presentation today. I might have to stop momentarily for a drop here and there just to medicate my left eye. The allergies here have been quite off the charts. That being said, welcome to Texas in April. April and October are the two best months of the year to visit Houston, where our weather is generally lows in the high 50s to low 60s to highs in the mid 80s. 2 months a year where the weather is beautiful. The rest of the other 10 months of the year, I do not recommend. But if you're going to visit Texas and especially Houston, you want to make your trip in April or October, which is one reason why the conferences are so significantly packed here those 2 months and why traffic is the worst October and April. That being said, we've got plenty of time this afternoon to go over the topics. So thank you for listening to my presentation and for your active participation. I did see a lot of questions, so I'm going to try to work in the questions from the audience as I provide discussion of the presentation. So a lot of my slides are primarily just to guide the audience. I'm going to provide content as appropriate. However, if you have specific questions like you fell in an elevator and maybe your employer's liable and you might have a workplace compensation injury, or your boss has been really rude and giving you all the assignments and not making everybody else do the same stuff, you may want to contact us individually about your specific facts. The intent of this presentation is not to go over anybody's individual case with too much specificity. I will give generic pointers, and those generic pointers may be applicable and pertinent to your specific case. Like, for example, when I talk about you, Sarah, if you told your boss you're joining the Army and then you're immediately fired, that scenario happens all the time. So if you happen to be in that particular situation, you definitely want to call us for an individual consultation about your facts. But there are certain discriminatory behaviors that reoccur pretty frequently, just like for the last 100 years, DUIs have been prohibited by law, meaning you're not allowed to drive while consuming alcohol. Every single day, people are cited, arrested, and fined, and incarcerated, and released for driving under the influence. So it happens every day, even though it's been banned for over 100 years, and we've done a million things to try to stop it. Similar things with employment claims. As much as this stuff is made unlawful, the behavior still happens. There's a lot of moral, philosophical basis for discussing all that. We're not here to have a philosophy session or a ethics discussion, but I can tell you human behavior is very predictable. It's why insurance companies are so profitable, because they run numbers based on events and they adjust rates based on predicted outcomes of prior occurrences, and they make lots of money off of it. So human behavior is still very predictable. That being said, when human behavior in the workplace is equally predictable. People are human, they have faults, and their faults cause them to engage in emotional behavior, which results in discriminatory conduct, which could be unlawful. So about me, I'm the managing partner of our Houston office. I've been in Houston, Texas, on and off for about 20 years now. I first moved to Houston in 2005 to attend law school at South Texas College of Law, Houston. I graduated there in 2008, passed the bar in my first try, immediately joined the Army JAG Corps during the financial crisis of 2008. With the economic collapse, I wanted to get some job skills and experience, and obviously the military JAG Corps was an opportunity that was available because I was a prior combat veteran, having served overseas in multiple deployments as a field artillery soldier. So I was able to thankfully escape the economic crisis by joining the military. And I served 4 years. 3 kids later, family decided to settle down in Houston. I've been in Houston for most of the last 12 years. Did have some time in New York for a brief period with our current firm, and I travel frequently around the world on behalf of our clients. My family is parked here in Houston in a very nice community, about 30 minutes away from the airport, and I frequently travel wherever the cases happen to take me. Recently, I've been, this past year alone, starting in January, I was in Richmond, Virginia, then I was in San Diego, California, then I was in Dusseldorf, Germany, then I was in other parts of Germany handling military cases for the Army. And then I got to go to Portugal, and then after coming back from Portugal, I went over to North Carolina, Fort Bragg, Fort Liberty at the time, now it's Fort Bragg again. And then from Fort Bragg, I went to Spain, came back from Spain, got to see Naval Air Station Rota, came back from Spain, went to DC. Well, actually, I went to DC before Spain, so I get it all mixed up. There's just too many places I go. But anyway, San Diego, Richmond, North Carolina, Washington, D.C., Spain, Portugal, Germany, all since January. So I average about 80 to 120 days a year on the road, and that's the nature of the practice when you represent members of the military. And I just got back from Dallas, where I attended the Northern District Bench Bar Conference, learning from federal judges on our cases there. So I handle about half military, half federal lawsuits in court in the state of Texas. I'm docketed for trial in the Dallas area, El Paso, Austin, Houston, South Texas. We cover the entire state. Thankfully, I'm in Houston, so logistically, getting to Dallas up and back the same day is feasible. Going to San Antonio and Austin, Harlingen, Laredo, you name it, is also feasible. Sometimes same day, sometimes it takes a day or two, but able to frequently travel the state with Southwest Airlines and travel the globe with United or Delta or American. And it's generally, because Houston's such a good logistics hub, it's equally distant between Florida and California, so I'm able to get to both places in equal amounts of time. Also able to spin over to the DC area quickly. We have a main office in our Washington, DC. It's our hub of federal activity. We have about 20, 30 lawyers in Washington, D.C., and we also have about 50 lawyers in the state of New York. We have a big presence in Manhattan, and we cover the entire state. So our firm covers Manhattan, White Plains, Albany, Buffalo, Rochester, Syracuse, Washington, D.C., and then we have an office in California, too, covering the Los Angeles area, primarily based in Orange County, but it covers all of Southern California. I'm actually docketed for trial in San Diego later this year. So I get to go to all those places and bounce between them. So, and why you might ask, why am I involved in that much? Well, as a managing partner, I have dozens of attorneys that report to me on a daily basis to do a lot of behind the scenes work. But when it comes time to facilitate the finalization of the case, you want the experienced attorney with the most gray hair and wrinkles and, prior experience to finalize the deal. Just like the neurosurgeon actually does the brain surgery, but before the brain surgery happens, you have somebody to check your blood pressure and somebody to change the bed sheets and somebody do all the preliminary work. That's how Tully Rinckey operates. Some people get confused when they do an initial consultation. They want the brain surgeon to do the entire duration of the case. Well, that's not how it works. Before you have brain surgery, you have an anesthesiologist put you under, you have a nurse check your blood pressure, you have an assistant change the bed sheets, you have a janitorial staff clean the room. We operate the same way. We have multiple people who do multiple things every step of the process. So I have brand new attorneys right out of law school. We have law clerks waiting on bar results. We have senior associates. We have up-counsel attorneys who've been around for 20, 30 years with lots of experience, but they're not necessarily a partner in the firm. And then we have several law firm partners who are practitioners in their specialized field. And then we have a group of leadership members who are the managing partners in charge of certain geographic office locations. I'm in charge of the Houston office. I'm also the assistant in charge of the Austin office, and I spend time between Houston and Austin frequently. But because we have office management attorneys in other locations, I'm also able to cover and assist any team for trial in any part of our firm's operation. So that's me. That's my background. I handle cases with the EEOC. I have experience primarily in federal litigation for employment on USERRA. USERRA is the Uniformed Services Employment Reemployment Rights Act, and it involves the anti-discrimination provisions protecting veterans and members who have military affiliation, Guard, Reserve, active duty, former members of the military. I also have a niche representing veteran-owned small businesses who were sued by the NLRB or investigated by the NLRB. So not only am I a plaintiff's advocate primarily for USERRA plaintiffs and Title VII plaintiffs suing for race discrimination, gender discrimination, religious discrimination, I also assist sometimes businesses that hire me. Individual, like a dental office, will hire me to represent them, or a bowling alley will hire me to represent them. We help veterans establish their small business through our VetCon program. So many of them establish a good relationship with us, and then if they get sued, they call us to represent them. So we can handle both sides. That's good because it's you have to have knowledge about how each side works. I would say 90%, 80 to 90% of my work is on the plaintiff side, but a good 10, 20% keeps me honest on the defense side. As long as I defend claims, the same claims I'm pursuing. How can I do that? Because we make sure there's no conflict. And in that process, I get to learn some insight about the defense bar and what the value cases actually happen to be. So it's really good information, inside knowledge about how these defense firms work and how they conduct themselves. And I use that knowledge to make my plaintiff's cases that much stronger. And my individual small businesses don't mind because they're not affiliated with these major companies we go after that are part of the Fortune 500. They're just a small independent business trying to keep the lights on. And primarily for a lot of our Title VII claims, they're against major employers that you'll see on the New York Stock Exchange who are making billions of dollars a year in profit and then not treating their employees properly. So that's how we can balance that out. We will take a case against a small business, but we have to make sure a conflicts check that we don't already represent them. But it's unlikely because I only have a few, not too many. There's millions of small businesses out there. All right, so we'll go on to the next slide now. That's enough about me and my background. Topics for today's webinar. We're going to discuss suing private employers in Texas. We're not going to discuss litigation against the state, city, municipality, or federal government. There's a reason for that. I wanted to limit this just to private employers because I'll tell you, let me give you a little secret here. It's horrible to sue government. Why? Because they have a free attorney assigned to them. Whether it's the federal government, they have the Department of Justice, free attorneys automatically given to the agency to defend whatever misconduct they've engaged in. Or say City of Houston, they get to use the taxpayer money to hire private attorneys that basically rip off the city. And it's a scam. The city gets invoiced for this work and the taxpayers pay it and the people who are elected to leadership get a kickback. It's been going on across jurisdictions for a very long time. It's not a secret. Everybody knows it exists. And I'm not saying anything unlawful about it, but it's very, very, very shady, very corrupt, and it's very, very unethical in my opinion. But again, it's my opinion. It's probably lawful conduct. And again, I will make a disclaimer at the beginning. Please don't call the firm to complain about my opinion. Call me directly. My number is 832-240-3273, and my email address is stimmons@tullylegal.com. The opinions expressed in my webinar are my opinions only. They are not the opinion of anybody else affiliated with Tully Rinckey PLLC or any of my colleagues. Several of my colleagues share different opinions than I do. Several of my colleagues may have different political views than I personally hold. My political views or my personal opinion may interfere with my objective assessment of the legal analysis to some extent. We're human, and that happens. If you disagree with what I say, you're free to do so. You're free to give me some feedback to say, hey, I don't think that was correct. I'm happy to entertain that and have a discussion with you offline. But please don't attribute anything I say to anybody else affiliated with Tully Rinckey, because the opinions expressed in this presentation are my opinions and my opinions alone. That being said, this is all based on my analysis of the law, and we're going to talk today about the demand letter process, the EEOC complaint. What is the EEOC? That is the Equal Employment Opportunity Commission. They have oversight over private employers in the country, and their job is to investigate claims of discrimination. We're going to talk about the legal basis to bring claims against private employers, some differences between workers' comp claims and employment claims and other types of claims you might want to bring. A premises liability claim. If you work at a hotel, you might get injured there. It might not be the responsibility of the franchise owner. It might be the responsibility of the place they're leasing from. Lots of complicated issues there that really are outside the scope of our presentation today. I do want to talk specifically about what evidence do I need to collect, acquire, and assemble before I go forward with an employment claim. A lot of people have employment discrimination theories, and those theories may well be accurate, but unless you have evidence to back up your theory, it's pretty useless. And I'm going to try to help people here today. How do we actually collect evidence? How do we document what's happening? Well, you want to save emails. You want to print those emails out before your access is cut off to them. If you're working for a company and things are happening and you see offensive emails being sent to you, print them out or screenshot them or take pictures of them, but save them. Don't let the company delete them after you've quit or been fired and then never have access to them, because you may not get back. You may never get access to it again. They may be gone forever, or you might have to get access to it, but after motions to compel and motions to enforce and $10,000 of litigation expenses. Gather your evidence, assemble it, and make it PDF. Zip drives are often not secured and cut out. Just save everything as a PDF and save it to your private email. Do I sue in state court or federal court? That's the only question we'll talk about. What type of claims can I bring in federal court? What happens after I file a lawsuit known as a complaint? What happens discovery in Texas? What does a jury trial look like? And what are some approaches to settlement? That's the overview of what we plan to go over today. Other topics include some other things I want to discuss, and I'll go through that briefly here momentarily. But we're going to talk about, in addition to what I just mentioned, is union contracts, collective bargaining, enforcement of private agreements, unpaid wages. I want to talk about the difference between being a 1099 and a W-2. Let me address that right away. This presentation is for W-2 employees. If you are a 1099 independent contractor or a K-1 business owner, the analysis is separate and quite different. This is intended exclusively for W-2 employees, meaning you file your taxes with a W-2, you get a statement of your earnings, you go to your tax preparer or you do it yourself, and you pay taxes as a W-2 employee. If you're a business owner or an independent contractor, a lot of the legal protections applicable to today's discussion do not apply to your case, and that's for a separate webinar. We're going to talk about some insight on relevant past cases with Texas employment litigation. What is employment discrimination? Okay, well, it requires two things. One, an adverse action, and two, a protected status. And let's go on to slide 5 now. What is an adverse employment action? Well, an adverse employment action is an action that materially causes significant disadvantage with terms and conditions of employment. This can include firing, being terminated from your job, demoted, not promoted when you should have been, not hired when you were most qualified, cuts to your pay, removal of your job title and responsibility, removal of your title, reassignments, the cutting or reduction of your hours that you were previously relying on earning. Those are all things that could be considered adverse employment actions. There's other potential adverse employment actions, but those are the big ones that we see lots of litigation on. Let's go to slide 6. What is a protected status? This is open for debate to some extent to what is this full scope of protections offered under law, but generally speaking, it's considered immutable traits, meaning race or sex and the exercise of legal rights. So you should be treated as an equal. This shouldn't matter if you're from Vietnam or France or Bulgaria or Australia or wherever, or Canada or Nigeria. It doesn't matter where you're from or what you look like or what your gender happens to be. What matters is your merit and your skill and your credentials and your ability to do your job. If you're treated not based on skill, not based on independently verifiable performance metrics, but on characteristics that are protected statuses, you may be the victim of employment discrimination. Protected status also includes, status as a veteran and other statutory protection statuses, being pregnant. Protected statuses are generally specifically delineated by law, such as being a Vietnam-era veteran or being an individual who's pregnant. If you're a pregnant woman and you're being treated harshly because of your pregnancy, not only may be a victim of disability discrimination, but you're probably a victim of sex discrimination, and they're violating the specific Pregnant Worker Protection Act legislation that makes it clearly unlawful to take adverse employment actions against individuals who are dealing with pregnancy. There's a fundamental public policy to promote pregnancy, to promote childbirth. The government wants new taxpayers, the government wants new citizens, and the government needs a new generation, and we want to encourage children. And if we're going to encourage children, we need to treat people who are carrying the next generation with dignity, respect, and the proper treatment they deserve and are required to receive by law. Unfortunately, a lot of individuals suffer pregnancy discrimination and are treated harshly for various reasons that are pretty absurd and awful. But it's predictably occurs over and over. Often you see, oh well, you're pregnant, so your hormones must be terrible. We can't trust you with anything because your judgment's off, or there's a million different excuses, but they're not legitimate. They're not lawful. They're based on discriminatory animus, and they're illegal. And we should try to stamp those out. So we see a lot of cases regarding maltreatment of individuals who are pregnant. And if you fit that status specifically, you want to talk offline, feel free to schedule a call. Let's talk about the next slide. Race, ethnicity. Now, racial discrimination in the United States has been against the law since 1866. As we know in our history, we didn't always enforce the law in many jurisdictions because of corrupt bargains after Reconstruction. For about 90 years, the 1866 Civil Rights Act was not enforced. I believe from the mid-1870s or 1876 until 1965, basically the law was simply ignored. That's pretty awful. That's the history behind racial discrimination in America. This is not a history lesson, but there is the 1866 Civil Rights Act, which starts Section 1981 of Title VII, which is its own provision. Now, the difference with 1866 Civil Rights Act and the 1965 Civil Rights Act is pretty clear. The 1866 Civil Rights Act only protects discriminate individuals who are descendants of the formerly enslaved. So if you happen to have ancestral lineage to prior individuals who were, held in servitude, you may have protection under the 1866 Civil Rights Act. 1965 opens it up to far more people, and it bans discrimination based on many other protected characteristics. Move on to slide number 9. That is the national origin. National origin does not necessarily mean the same thing as race. So you can be Canadian, but have a French-speaking background. So you might assume Canadian would be, Caucasian, or you might be Canadian, but be Asian because your family came from China 60 years ago. You don't have to necessarily be a certain, ethnic background to have a national origin distinction. You could be, ancestral from China, living in Quebec, knowing French, and move to America and be speaking French and be required to learn English and maybe face hostility and discrimination based on your national origin. And your national origin could be multiple different scenarios, as I just described. As globalization has caused the movement of people around the world, you see a large Vietnamese population in the Czech Republic. You see a large Japanese population in many parts of the world where you wouldn't necessarily believe you'd see that. That same thing with Canada, America, where we have very diverse populations. And these diverse populations, people need to get along and hopefully do get along at the workplace. But predictably, it doesn't happen all the time. And if there's discrimination based on it, it's generally unlawful. Let's go down to next slide. That's religious discrimination. Religious discrimination is the same thing. Some people have cultural affiliations with certain faiths, such as being Jewish, and they wear certain clothing based on their faith, or being Muslim, or many other religions. Christian, wearing a cross around their neck. Some people self-identify certain religions, and it's obvious what religion they are based on the item of clothing they're wearing. If that causes them to be targeted for maltreatment at work, that's unlawful. So if you wear a, clothing attire that indicates you may be Jewish and you're treated terribly at work, that could be unlawful behavior. That's discrimination. That's not permissible. If you're mocked for your religion because people tell you you're part of a cult, or they tell you you're satanic because you have a picture of the Pope in your office, that could be unlawful behavior. There's a lot of anti-Catholic bias in America, a lot of hostility towards Catholicism. It's been around for a couple hundred years, and it's still present to this day. Same thing with all the other religions, Jewish faith, Muslim, you name Buddhism, you name it. There's a lot of cultural hostility to certain individuals with certain faiths. All of that at the workplace is completely prohibited. And if you're treated differently based on your religious practice at work, you're a victim of discrimination and you may have a claim. You could also have a claim for any kind of mockery or maltreatment based on your religion. And we're seeing more and more of that as some people grow hostile to religious practice entirely. If you're not given accommodations to attend religious services, you could be a victim of discrimination. Your employer should not overtly interfere in your religious observance. At the same time, it's a business necessity for you to attend work. You may or may not have a claim. There's a lot of fact-specific issues there. So if you're a doctor on call, but you want to be at church, you might have to perform your work duties and go to church some other time. There's a lot of business justifications to override your religious practice. But generally, religious practices should be accommodated to an extent reasonable. Let's go on to the next slide. Disability discrimination, another one. President George H.W. Bush passed and signed into law in the late 90s the legislation, or maybe early 1990s, called the Americans with Disabilities Act. And the Americans with Disabilities Act basically said employers should work to provide accommodations to individuals with disabilities. So as long as they can perform essential functions of the job, they should be given an opportunity to hold the position. So if you're in a wheelchair and you're being rejected that should not be something that happens automatically. Now, if you need to lay bricks on a roof, maybe being in a wheelchair, it's impossible, and no accommodation will make that doable. If your job is to be a window washer and you're in a wheelchair, it may or may not be possible. So not all accommodations are required. However, to the extent it's reasonable, employers should make accommodations for individuals with disabilities to do certain work. There's a case law on that regarding, law enforcement and wearing a hearing aid. Law enforcement requires, good hearing to be able to respond to emergencies, and if your hearing is diminished, requiring an aid, it may be lawful for law enforcement to discriminate against you, even though you have a right to medical accommodations. That's one reason why a lot of law enforcement officers are obese, is because the American Disabilities Act protects obesity as a medical condition. So having laws that say you can't be a certain height, weight for private employers or government entities that have to comply with the ADA, generally, you're allowed to have a medical condition, but there is a lot of gray area there. They can set medical standards, and that's a further discussion for a later time. So some jobs, disability discrimination is permitted to the extent it's related to the official functions of the position. And usually you find that with law enforcement or other, high-level, risky jobs like that, where life is on the line and stuff. But if it's like an office job, they usually need to make reasonable accommodations. Now, not all accommodations are required. If you have active hallucinations or delusions and your job is customer service, you may not be able to perform that position because you may be a safety risk to the customers who are coming into you're interacting with, especially if you're actively deluding at work or something. So there's a lot of gray area when it comes to disability discrimination accommodations. Let's move on to the next slide. What is a disability? Disability could be a physical or mental impairment that limits your activities. Next slide. What is disability discrimination? Discrimination is when you are denied the opportunity to perform the reasonable functions of the job, even though you are capable of doing so. Again, the wheelchair example is a great situation. If your job is to, type stuff on the computer and your hands and arms work correctly, but you happen to sit in a wheelchair, you can't walk, you should be given an opportunity to do that job just as somebody who's more able to walk. Your ability, that should not interfere with your ability to get an accommodation. Again, if it's law enforcement and you need to be somewhere quickly, there may be a gray area where discrimination is permissible to some extent. And again, the military is allowed to conduct all kinds of discriminatory bases when it comes to disability because the ADA does not apply to the military. So the American Disabilities Act flat out does not apply to the military. People come to me all the time and say, hey, well, my kid or my son, I was denied ability to join the military. Is this disability discrimination? Well, they're allowed to selectively discriminate based on disability disqualification for the military. So it's unfortunate, but the military operates under a whole different set of laws than private employers. So just keep that in mind. Let's go on to the next one, genetic information discrimination. This is a whole new area of a law that's developing. I just want to touch on it briefly. This is a whole other area of the law that is evolving, and I'll leave it to the fact that genetic information, as technology is changing and biotech is advancing, there's whole kinds of discriminatory bases to say, oh, your genes suck, so we're going to discriminate. If that's happening, you may be a victim of, you shouldn't be required to undergo genetic testing before you take a job. But some companies in some states and countries have tried to do stuff like that already, and it's unlawful generally. So genetic information discrimination is prohibited. Let's go on to the next one, age discrimination. It shouldn't matter what age you are. Yes, as you get older, life gets harder. I can attest to that. I'm 45. When I was 25, I ran faster, I ate more, and weighed less. Now that I'm older, life's different. But as an attorney, I would say it's one of the few jobs that the older you get, the better you are at it. Whereas if my job was a runner, I would be a lot worse at my job because I can't run nearly as fast as I did 20 years ago. But my job today as an attorney, I'm a lot better at it than I was when I started because the more knowledge you acquire, the better you get at it. So generally, older employees are more valuable than younger employees simply because they've had more time to acquire more experience. And the more experience you acquire, the better you are at your job. Generally, you'd think the older you get, the more valuable you'd be. However, if you are older and you're being forced out for age, that's unlawful. Some people hold the view that they want quote unquote fresh talent, young blood, because they're more moldable, they're more obedient, they're more trainable. That's an unlawful basis to remove individuals, and if it's being done based on age, that's completely illegal. And people are often targeted to get kicked out because they get older. And sometimes employers may think, well, they're older, so they're going to need more medical appointments, they're going to be slower, they're going to be more problematic, they're going to be more stubborn. We want people who are younger and follow directions and don't question anything. That's unlawful. And if you're a victim of that, contact us. Next one, next slide, sex discrimination. I apologize. There's a lot of slides to go through here because there's a lot of topics to cover when it comes to what you can sue your employer for in Texas and nationwide. This covers everything I've talked about so far. Generally is applicable everywhere. And this slide is wrong because it's an old slide. So it says does not include sexual orientation. Since 2020, sex discrimination does include sexual orientation. So I need to update the slide there and send on a revised vision. That last sentence is not accurate. Since 2020, I've been giving this presentation for years. Since 2020, sex discrimination includes whether you're man, female, transgender, and it also includes sexual orientation, meaning whether you happen to like the opposite sex or same sex. Discrimination based on that is unlawful. Okay, the Federal Pregnancy Discrimination Act prohibits, protects pregnant mothers. Talked about that already. Move on to the next slide. Okay, slide 20 now. Sexual orientation discrimination and salary history issues. I want to talk about this briefly. Salary history questions are lawful in Texas, but they're unlawful in New York. And they're unlawful in other locations to be determined as laws change. I wanted to bring this up because since 2020, sexual orientation discrimination has been prohibited. So you cannot make adverse employment decisions if somebody happens to identify as, say, lesbian. In the past, it was lawful to discriminate based on that characteristic. It's now unlawful. There is a minor exception when it comes to like religious practices of certain religious-based employers. Certain religious-based employers are allowed to discriminate to some extent based on some of these laws that protect everybody, but there's very, very, very narrow religious practice exceptions to those, and that's beyond the scope of today's presentation. So when I say these protections and I say these applicable anti-discrimination provisions, do keep in mind there's probably an exception somewhere every scenario because of some legislative statutory protection that provides an exception to somebody, or a case that says, well, it doesn't really apply in this scenario. So that's why you have to have legal analysis on no matter what the facts happen to be, because there's no such thing as a universal rule where everything is automatic. There's always exceptions to everything, which is kind of scary because you don't really know the full scope of the situation to really dig deep into the facts. But here in New York now, you cannot ask about salary history. The intent was to stop perpetuating cycles of unfair pay. Generally, in the past, for negotiations, and this is just scientific studies have showed this. I think I read about this in Psychology Today. So don't shoot the messenger. But according to Psychology Today, again, I'm not agreeing necessarily with this, but men, when they demand salary, will oversell themselves. Say, yeah, I'm worth $200,000 a year. Pay me that or I walk. And women will come in and say, well, I'd like 100,000, but I'll take 90. And employers, when chosen the two options, we talked to this blowhard guy who wants 200. We talked to this nice lady who wants 100. Let's offer the job, and she said she'll take 90. Let's offer her 85. She takes it. Oh, she took 85. Great, and we were willing to give 150, but she took 85. So let's give her 85. And that kind of thing happens, unfortunately, all the time. People undersell themselves because they're humble, and other people oversell themselves because they're full of crap. And employers sometimes will offer the individual with the lowest ask and give them that low pay. And generally speaking, according to Psychology Today, more women than men would be the more humble and willing to take the lower pay than men. More men were, braggadocious and pounding their chest and foolish and demanding pay that they never would have gotten anywhere anyway. And more women were reasonable and I'll take what I can get type scenario. Again, I'm not saying I have any factual basis to support this. I'm saying I read studies from the College Today that show this. And that could help explain why, generally speaking, across the economy, men and women are paid less because they simply don't demand it when they get hired. And employers if somebody's willing to work for less, are happy to accommodate because it makes business sense. And that results in pay gaps and salary discrimination. So to try to undo that, no salary questions, and everybody should get paid the same regardless of sex. But we know it doesn't happen. We know many women make less money than men for doing the same work, and often it's because the employer can go back and say, well, they asked for this much, and we gave them what they asked for, and the men asked for a lot more. So my advice to everybody is do your research on what the salary range is, and always start high and take and be willing to concede a little bit. Don't come in desperate, willing to take whatever you can get. Come in, proud of your accomplishments, proud of your credentials, and see what the best value you can obtain is for you and your family. That's just generic advice applicable to everybody. Don't be willing to take the first offer you get either. Be willing to negotiate your salary and try to negotiate the best salary you can possibly achieve without being unreasonable. And that requires a lot of information outside the scope of today's presentation. Not protected. What is not protected? Well, there's a lot of things that are simply not statuses that are you could use as a basis to discriminate if it's a right to work type state, which Texas happens to be. Whether you're rich or poor, you can use that as a basis. What state you come from, a lot of people relocate to Texas and they're not natively born here. I for one, am an example of that. I grew up in New York for my first 19 years of my life. And when I interviewed at law firms in 2006 in Houston, Texas, as a 1L law student, I would tell people where I grew up. And the next statement would be, well, get the hell out of here. What the hell? You're from New York. What are you doing in Texas? Well, I joined the Army and I ended up in Texas. Get the hell out of my office. I don't want to talk to you. Well, that was lawful because I was from New York. And I happened to experience that many times in recruiting at law school because I was not from Houston. I was not native to the city. And because of that, many old school Texas oil type employers or Texas lawyers at the time would not even want to consider somebody relocating from another part of the country, even though the military is the reason I was here. They just were horrified by the fact that somebody from New York would dare demand a job in Houston, Texas. That's the legal community. I don't know how much that happens in other states, and that was 20 years ago. I don't think that kind of discrimination happens as much today in Texas as it did then. But I can tell you, 20 years ago, a lot of older Texas attorneys who were in charge of law firms would literally want to puke when they heard I was from New York originally. And I've been in Texas now for 25 years. I consider myself a Texan, but I still, have ancestral roots in New York. So I've experienced that discrimination myself, having gone through law school and talked to Texas-based Houston law firm employers. And many of them would only want somebody from Houston. And if you came even from Dallas, they wouldn't want to talk to you, which goes to the sports team affiliation. If you're a Cowboys fan, they don't want to hire you, maybe nothing you can do about it. Political affiliation. If they want to have only people who are progressive or only people who are conservative, that generally is permissible. Whether you drink alcohol or not might not be protected status. Where you went to college. Yeah, many employers say, you know what, we only want to hire grads from these schools, and that's it. If that's their criteria across the board applied to everybody, that might be lawful. Remember, many law firms proudly say, we only hire the top 10% from the top 10 schools. That's it. Don't even bother sending a resume to us if you're somebody outside that scope. They lose a lot of good legal talent that way, and they end up having good, successful careers at other firms, such as ours, where we take in people from any law school because we don't care where you went to law school. We care about your skills and your performance and your capacity and your merit-based drive. We don't care where you went to law school. I mean, it helps to have gone to a good law school, to be knowledgeable as an attorney, to become a good practitioner, but we won't turn you away if you went to school number 150 or school number 1. We will welcome anybody from any law school. But many employers, many law firms are very snobbish and say, nope, they will only take people from these law schools. And there's nothing unlawful about that, which is quite shocking, but that's not where you went to school is not protected status. Potentially, your education criteria and criminal history might be protected. In New York City, for example, criminal history discrimination is unlawful to some extent. There are exceptions for certain jobs, but generally speaking, having a criminal record should not automatically disqualify you from having a job. The way they get around that is Some jobs require credentials. You have an accounting license, you have a law license, you have a teaching license. You're not going to get a teaching license if you have a felony conviction. You're not going to get a law license if you have a felony conviction. So sometimes having convictions for felonies prevent you from having a license, and if the job requires a license, you may be discriminated against based on your criminal history. So that's why it's a maybe. If your job is, if you're looking to work at Subway as making sandwiches and you have a felony in your record, there should be no discrimination if you can do the job and you don't have any restrictions on your ability to show up to work. But so again, it's really job specific on criminal background. Ways employers discriminate against protected statuses. Okay. At least 5 different ways people are victim of unlawful discrimination. I've touched on a lot of this already, but there's disparate impact, disparate treatment, failure to accommodate, hostile work environment, harassment, retaliation. All right, disparate treatment means you're treated differently than others based on the characteristics we described. So if you're Catholic and you're told, your office is in the closet and everybody else gets to have a nice view of the river, that could be unlawful treatment. If you're disparate impact, where they require, everybody to speak English only and at the workplace exclusively, no matter what the conditions are, that could be disparate impact because you might speak native French because you're from Quebec, and that could be having an impact on you that's unlawful and unnecessary. There's other disparate impact. It could be things that affect women only or men only or people who are from certain backgrounds only. That could be an unlawful basis. Failure to accommodate primarily goes to medical suitability issues and medical accommodations. Hostile work environment, that's a big one. Harassment. If you're being given, sexual advances at work constantly, again, a lone flirtatious advance may not be unlawful. Repeated unwanted advances are unlawful. Notice the terminology there. Being asked out on a date and you say nope, that's nothing unlawful about that. Is it improper? Possibly. Is it a misuse of status if it's your supervisor? Probably. Is it automatically illegal? No. Now being asked on a date 5 times a day for 2 weeks in a row, clearly that's a hostile work environment, that's harassment, that's unlawful. I gave 2 extreme examples there. Why? Because generally speaking, the court, especially the Fifth Circuit, has stated a lone off-the-cuff statement at work, calling somebody pretty, saying somebody's handsome, saying somebody's a sweetheart. Isolated statements like that are not unlawful. It requires repetition. It requires then you to affirmatively come out and be like, hey, stop doing that. And if they don't, then you have a claim. But you generally have to take steps to object if you, unless it's completely unreasonable, like being assaulted or being, physically harmed. That's different. But if, for example, there's elderly women at work who like to, wear a suit. Oh, you're so handsome. Just generally laugh it off. That's not discrimination. That's not a hostile work environment. That's not sexual harassment. But if it gets to the point where they're like tracking me down in the parking lot, that could be, and trying to tackle me, that could be criminal and hostile work environment. So it's fact specific. Retaliation, same thing. Being asked to come into work early because you complained the day before about the assignment may not be retaliation. Calling OSHA about workplace safety issues and then being, forced in every weekend to mop floors clearly looks retaliatory and probably is, especially if that's outside your normal job description, because you made a protected communication. So not everything that happens to you at work fits under the retaliation category. But if it fits under the protected status, it could be unlawful retaliation that entitles you to recovery and action. Let's go down to next slide. Disparate treatment. This requires proof of intentional treating employees differently and less favorably because of a protected status. Employers often have a lot of excuses. For example, there's the Hooters case. Men applied to be waitresses at Hooters, and Hooters was allowed to keep their hiring criteria the way it was because it wasn't considered sex discrimination because the job description required that particular, individual to perform that job in that manner. So you would think that doesn't sound right, but the example here on the slide is an Asian restaurant requiring only an Asian chef. There are examples where a bona fide occupational specialty requires some disparate treatment different. For example, a seedy establishment that is also known as like a strip club can discriminate against individuals who are obese because the bona fide occupational specialty would be customer, wanting what they want to see. And if you don't fit the criteria, they might be able to lawfully discriminate against you. So there's lots of those types of scenarios. Again, I apologize if that's a crude example, but trying to think of something to articulate, or if it's a job requiring historical reenactment, they might be able to say, we want somebody that looks like Abraham Lincoln, and only Abraham Lincoln because he's going to play Lincoln. Those kinds of things are generally discrimination that is permissible. Next slide. Common defense. Yeah, this goes back to the business has to show necessity. If they can show necessity, they can get away with it. U.S. Marshals is an example. Law enforcement is often able to discriminate because they can say it's a requirement for the job. So there are sometimes legitimate business concerns that allow some discrimination. This is when a policy is neutral, but it harms individuals from certain jobs. So the employer has a neutral height and weight criteria, but it eliminates lots of women. It could be sex discrimination. That's unlawful because although it's not intentionally discriminating against women, if it causes a massively disparate impact and limits women's ability to show up and do the job, then it could be discrimination that's unlawful against women. C says education requirements from background checks can result in disparate impact and can be unlawful if they're done inappropriately. So again, you have to have legitimate business concerns for certain credentialing. If you're requiring, say, a master's degree for a job that really only requires a high school education, that could be considered disparate impact unlawful discrimination. Because if the job is to make sandwiches and you're saying you have to have a master's degree to make sandwiches, that's absurd on its face. But there are some employers that want to get around these anti-discrimination provisions by making criteria that certain people just won't fit, and that could be considered unlawful. Common defenses for disparate impact, again, this business necessity and reasonable factors other than age or bona fide occupational specialty. If you're an employer listening to this, or if you're on the defense side, there's lots of ways to weasel out of these protections for a whole nother presentation. Failure to provide reasonable accommodations. Generally, the employee, and this is something I want to make clear, you have a duty to disclose the facts that require you to have an accommodation. I can go on all day. People tell me, hey, they discriminate against my disability. Okay. My first question is, did they know you had a disability? Well, yeah, everybody knew I had it. Okay. Did HR know? Well, no, I never told you about HR. Okay. You need to tell HR. You need to tell human resources. You need to tell your organization's leadership. You have a disability. You need to affirmatively disclose that if you want accommodations and protections to provide some reasonable modification to your job duties and descriptions. Just assuming because your boss knows does not automatically make the entire company liable for giving you an accommodation. You have to disclose it. Now you can do it confidentially. You don't need to tell you don't need to get on a loudspeaker and tell everybody at the plant that you have this problem or issue or need accommodation, but you should disclose it to leadership and HR so you can get the accommodation. You have a duty to disclose if you want treatment that's going to give you an accommodation. Otherwise, you have to follow the rules and do the criteria as the job requires of everybody else. You have an affirmative obligation to seek a reasonable accommodation by disclosing whatever impairment or condition necessitates that accommodation. And you have to document that in writing. Please don't come to a lawyer 6 years later to say everybody discriminating against me because I have ADHD and they didn't give me time off because of my ADHD. Well, did they know about it? Did you document it? Did you write it down? Did you specifically articulate that's your condition? Did you provide medical evidence to back this up? If you didn't do any of that, then you don't have a leg to stand on. You need to document everything. And if you need a letter from a doctor, prove it, then you may be required to go get independently corroborating evidence. And they may not just rely on your individual assertion. Like if you can't see and you need accommodations based on sight problems, you might need to show them a report that shows that from an eye doctor. Those are things employers can require lawfully. Next step. Again, it's all fact specific. Not all the time can they require stuff like that. Failure to provide reasonable accommodations. could be actionable and could result in some liability. All right, let's go down to slide 32. Running out of time, so I'm going to have to go through these a little quicker than I anticipated. Harassment. Again, unwelcome offensive conduct that is severe or pervasive. Notice the word severe and pervasive. I already talked about this earlier. A lot of people make an assumption that they've been harassed, which may be a legitimate assumption, and it may be true. But the law only criminalizes and prohibits severe and pervasive harassment. What's severe and what's not severe, that's a huge gray area. And that's a whole other presentation, because some people would think some misconduct, is severe automatically, and other people would think it's not. The law has to be uniformly applied across the board. So generally, it has to be objectively severe, objectively pervasive, and significant. Again, being asked out on a date, probably not severe. Being groped at work, obviously severe and pervasive and hostile and even potentially criminal. So there's a massive difference between those two. The reason for that is to show one, which is obviously severe harassment, and the other, which is not necessarily problematic at all. But it could be if it's repetitive and continuous and goes on for a significant duration. You have to know the difference between that. Enduring offensive conduct at work becomes a condition of continuing employment, quid pro quo. So if you're told to sleep with the boss to get a raise, that's obviously unlawful and prohibited and potentially criminal and actionable. Let's go on to the next slide, slide 33. If supervisor requires conditions of continuing employment on submitting to harassment, that is quid pro quo harassment. That's the most obvious kind of sexual harassment, and that's completely unlawful. Next slide, 34. Okay. This is the part I was trying to get at on the slides here very clearly. For the harassment to be actionable, it must be severe. Petty comments or stray, isolated comments, even if they are crass, inappropriate, foolish, obnoxious, middle school boyish type nonsense, that may not be unlawful at work. And you would want a bucket of them to document if you're going to say it's pervasive enough to cause you a hostile work environment. Many people call lawyers after one uncomfortable experience at work. You need a lot of them for it to be actionable. Unfortunately, that's just, now if you want to quit because you don't want to work there, that's your prerogative, that's your right. But for it to be unlawful behavior, it has to be severe, pervasive, and continuous. And that's the issue. Doesn't mean you have to submit to it and keep going back there. You can quit anytime you want, generally. But if you want to sue for it to be actionable, you definitely need to have lots of evidence to show the pattern, and it has to be pervasive and continuous. And employers get a lot of outs on that to show that they protected people by providing just protections, and this was outside the scope of employment. Let's go down to the next slide, liability for harassment. All right. You have to show, now if you were forced out because you wouldn't submit to the harassment, that may be constructive discharge, and you may have a case. You may be able to, go after your employer because you wouldn't put up with the nonsense anymore. Liability for harassment. One warning about the doctrine of constructive discharge in Texas. Texas almost requires you be under duress for it to be considered constructive discharge. Your claim in Texas is a lot more valuable if you're just fired. If you quit and say constructive discharge because your conditions at work were terrible, you almost have to show you were about to face torture. That's how severe the standard for constructive discharge is. You have to show you were subjected to being forced to engage in unlawful activity, or the conditions were so extreme and so outrageous that the only other option you had was to quit. So being treated badly at work in Texas is generally not sufficient to meet constructive discharge. One reason why the population of Texas has gone up from 20 million to 30 million in the last 15 years is because employers love moving everybody to Texas because they know, speaking generally, they can treat their employees like crap and get away with it because the liability for constructive discharge is so hard to prove in Texas. Meaning in Texas, you can get paid less, work harder, be treated more miserably, and the employer gets away with all of it and makes a lot more profit. That's why so many people have moved here. It's been a great marketing scam for the state and for the realtors on this call because they get to sell lots of homes and people get to move here, but the employers generally benefit from treating their employees much worse in Texas than any other state in the country. Because if you quit for being treated badly, you have to almost show that you were about to face torture or be a gun to your head to commit a crime in order to advance a constructive discharge claim in Texas. They're very, very hard to prove, which is why my advice is if you think you're going to get terminated, and wrongfully so, based on a protected characteristic, it's best to just wait to get terminated and quit, unless you have a much better job lined up, because showing constructive discharge is nearly impossible. Not impossible, but about as close to impossible as you can get. In Texas, at least. Liability for harassment. Retaliation. I want to talk about this. An employer attacks an employee for complaining about discrimination. That could be a violation of NLRB Wagner Act. If you complain about your salary and then you get fired, that could be unlawful interference with your rights to bargain for better conditions at work. It has to be a protected activity. So demanding better workplace environment, demanding better compensation, better benefits, and you're attacked after that, that's unlawful. But you have to show the nexus between that. Saying your office, smells bad and then you're being put in a different office that's even worse, that may or may not be retaliation. It really is fact specific. But if it's about like your salary and you're fired after asking for a raise, that could be a violation of the Wagner Act. A lot of businesses get in trouble for that exact scenario. Somebody demands a raise and they get fired. That's a violation of the Wagner Act. If you're asking for a change in the conditions of your employment, you can be denied the raise, but you shouldn't be fired for it. And if you are, that's unlawful. That's unlawful retaliation. That's a clear example, and I see it all the time. Employee Retirement Security Act. Okay, there are certain plans that require protections. Next slide, 46. The National Labor Relations Act. This is the law that protects you for asking about activity and organizing, unionizing behavior. Slide 48, please. Workers' comp. Workers' comp outside the scope of our presentation today, but if you're hurt at work, you generally are entitled to compensation and medical recovery and time off for disability accommodations to heal up and return. Same thing with the Family Medical Leave Act. If you are eligible, slide 49 now, please. If you're eligible for the FMLA, you are entitled to time off to care for family. So lots of protections there. So now I want to move on to slide 54. We talked about a lot of the law. And we're going to move on to which Texas court to file your lawsuit. So let's assuming you're a victim of race discrimination, religious discrimination, retaliation, you name it, any of these things here. Before you go to court in Texas to sue, you generally have to exhaust your admin remedies. There are other presentations that discuss this more thoroughly, but you have to file a complaint with the EEOC to get a letter that's called your right to sue. If you have a right to sue letter, then you're able to go to court. Where do you go? Well, there's 4 different districts in Texas. There's northern, eastern, western, and southern. Southern covers Houston, western covers Austin and El Paso, eastern covers Tyler, Sherman, Beaumont, Texarkana, northern covers Amarillo, Lubbock, Dallas. Move on to the next slide. What type of employment claims to file in Texas federal courts? That would be, Title VII, race discrimination claims, national origin, religion, and USERRA claims, the Uniform Services Employment Reemployment Rights Act. There's going to be another presentation discussing the contours of USERRA specifically at a later time. So I would ask you, if this is, say, 2026, at the conclusion of this presentation, if you want to listen to the webinar on USERRA, that'll go into further discussion on USERRA protections and the applicability of veteran status to employment discrimination claims. This presentation here on April 14, 2025, just gave you a generic overview of all the different bases to discriminate to sue for discrimination against private employers in Texas. But it's very, very high level overview of covering what claims you can bring and what the bases happen to be. There's going to be several more webinars, and this is the beginning of a series of webinars. And in the future webinars, we're going to get into the specifics. And the next one I'm going to do is on the Uniform Services Employment Reemployment Rights Act, going into the weeds of USERRA specifically. So if you're watching this again in the future, you want to tune to the next webinar on USERRA. What happens after I file a complaint? Well, what happens is They have the right to get it served by a service processor, and then you have to wait for an answer to be filed. Court issues a docket control order, and the case gets docketed for trial and litigation and disposition for the duration of the litigation. So lots of activity there, lots of stuff to talk about. There's other presentations from last year by Nathan Timmons and Mike Fallings discussing the contours of federal lawsuits. I would encourage you to tune to that 2025 presentation. So let's go down to slide number 59. What does a jury trial look like in Texas? Well, a jury trial is usually about 1.5 2 years after you file your lawsuit. Hopefully your case settles before then. I did want to talk about case settlements in this presentation, but I'm kind of running out of time, but I'll give you a pointer. Employment claims are not, generally speaking, worth millions of dollars, unless you were paid millions of dollars. So if you're a star athlete, baseball player, and you have a breach of contract against the Yankees, as you were supposed to be paid $20 million a year and they only paid you 10, your claim might be worth multiples of millions of dollars because you were underpaid the wages you were entitled to receive. Unless you're a highly compensated individual making $500,000 a year, your claims are not going to be worth millions of dollars, just automatically. There's statutory limits to damages. For emotional damages, the statutory limit for Title VII is $300,000. Under USERRA, there are no emotional damages. In fact, USERRA is very formalistic, very straightforward, very simple. You're entitled to recovery of your lost wages, and then if they find that the actions were intentional, you're entitled to up to 2 times. But no employer is going to automatically pay you 2 times because no employer is going to come out and admit they discriminated against you intentionally. So you have to keep in mind, employment claims, the valuation is not automatically very high. There's a reason for that. Congress gets donations from employers. Employers make sure that their exposure is limited by paying Congress to keep their liability exposure limited. Congress passes laws to tell their constituents, you're protected, but then protects the employers who fund their campaign by making their liability hard to prove and their damages low if they get caught. And the damages are kept low because you're generally only allowed to recover your salary. And let me give you another secret. If you are working at Marriott and you're making $20 an hour and Marriott discriminates against you awfully, harasses you terribly, and you quit, and the next day you go work across the street from Hilton, making $25 an hour, all that unlawful behavior at Marriott is now basically in the toilet. Why? Because you're making more money, and they get off the hook entirely. So Hilton's paying $25 an hour. Everything that happened to you by Marriott is pretty much water under the bridge. You may be entitled to nominal damages. You may even be entitled to emotional damages if it was severe and egregious enough. But your lost wages claim is gone because you're now making more money at your new employer. And generally, your settlement value is based on a formula of a percentage of the lost wages you would have earned had you kept your job. There's other mathematical formulas, front pay, back pay, all kinds of different analysis. But generally speaking, employment claims are not the same as having a Pepsi driver who's drunk run over your foot and cause you to have to be in a wheelchair for the rest of your life. That kind of scenario, your claim is worth millions of dollars. And if you have an injury claim, you'll see people who are unable to work for the rest of their life will be paid millions of dollars because of an injury claim. Employment claims are, generally speaking, not that financially lucrative because the formula is based on your lost wages. Now, if you have a contract dispute because you were an executive director entitled to payment of, say, stock options, and the stock price went from $3 to $300, and you should have received millions of dollars in benefits, and they fired you before your stock options vested, your claim could be worth millions of dollars, and it may be worth going to mandatory arbitration in Vienna to fight for that $1 million payment you were entitled to. If that happens, call us. We'll help you out. But generally speaking, if you're working at a gas station making $12 an hour and you get fired, and you go across the street to make $12.50 an hour, you probably need to move on with your life. There's not much we can really do because your wages are now better than they were at the prior place. So keep all that in mind when it comes to what you can do for suing and going after your employer. So with that, I'm going to take about 5-10 minutes to answer some questions people came to me with in the slides, and I'm going to answer some pre-submitted questions at this time. I got a bunch of them, so I'm going to try to walk through them as quickly as I can. We went over the hour, but I'm going to keep going because I don't have anything else on my calendar. First question I've got from an audience member is statute of limitations. Can you still sue after that? Well, the answer is probably no. Under USERRA, there is no statute of limitations. So USERRA discrimination, anytime you're able to go after the former employer. But for employers, again, Congress being, in the pockets of employers, getting all the money from employers who donate to them, and they donate to both sides. And in my opinion, Congress for a long time was kind of like Pepsi and Coke. Democrats are Pepsi, Republicans are Coke, or vice versa. Didn't really matter, but the same thing. But they would pretend they were something different. So, and the way IBM or Tesla or Apple would get around all that was they donate to both sides. And so no matter whoever wins, they win. And the law would say, there's very strict limitations on when you can bring your claims. Why? Because employers don't want liability out there forever. They want it cut off quickly. If you have an employment claim, you need to bring it immediately. You need to file with the EEOC right away. You have 6 months from the date of the act. And if you want to do a demand letter first, you need to move on it quickly. You can't wait and go back and sue on discrimination claims years later. The law doesn't allow you to do so. Unless you have the application of the doctrine of equitable tolling. So if you were in a coma for 10 years, and the coma was caused by a workplace injury, and before that happened, you were facing discrimination, you might be able to use the doctrine of equitable tolling to get around the statute of limitations. But it's extremely rare scenario and extremely unlikely to be applicable. So statute of limitations are very harsh in employment claims. My advice is to move on your claims immediately. Otherwise, you may lose simply by the clock being run out. At-will employers. Yeah, at-will can do a lot of stuff. It's shady and terrible, like I was describing before. When I applied for jobs as a brand new law student, I was told, I'm from New York, get the heck out of my office. That was lawful. Was it discriminatory? Yes. Was it abusive? Yes. Was it unethical? Yes. Was it illegal? No. And I couldn't, nothing I could do about it? Unfortunately, no. So sometimes at-will employers can do stuff like make you wear a green tie. Might sound silly and ridiculous, but if that's their condition of employment, that's totally lawful. Can you sue employers who are outside the United States? Generally speaking, yes. So if a company's based in Japan and you're working for them in America, can you sue them? Yes. They should have a registered agent in America. But again, talk to an attorney about that. Most international employers can get sued in America. I will caution you, if you're an executive director working for a company, say, based in Germany, and they move you to Austin, they may have on page 385 of your employment handbook a document where you agree to mandatory arbitration. Sometimes I end up in Europe in mandatory arbitration for employees because executive directors signed an acknowledgement saying with their employer, yes, if I ever get fired, I agree to mandatory arbitration by the Helsinki Arbitration Committee. Well, you may end up going to Helsinki if you're trying to go after your $1 million stock options you were deprived of. Because if it's mandatory arbitration, you have to go to the location of the arbitration, not the federal court. That's a whole other topic for a whole other presentation. We'll talk about that in a later slideshow presentation. Retaliation, next question was about collective bargaining agreements. You have to look at the terms and conditions of your agreement, and that'll determine the scope of liability one way or the other. And I'd ask you to talk to your union rep and or talk to an attorney about the conditions and terms of your CBA. Next question was about discrimination against those with sleep apnea, ADHD, anxiety. Yes, if you have sleep apnea and you need a nap during the day because it helps you out with your sleep apnea, that may be a reasonable accommodation your employer is required to provide. So if your job requires, say, 10 hours of output, but you need a break during the day because you have sleep apnea, so you take a nap and recuperate, you might be required to have that. For example, some law firms have to buy couches so their attorneys can take a nap during the middle of the workday because they need rest because of their medical condition. That might be a reasonable medical accommodation. Then again, not every job can require someone to take a nap. If your job is to drive a truck from El Paso to Houston and you got in a certain time frame, you may or may not have that same level of accommodation. So every job is different on that. Somebody asked here, they were fired after they were lied to, and the unemployment office. Unemployment claims, I did not touch that. Unemployment claims are state specific, state statute specific. It's always advisable if you're fired or quit to file for unemployment. Whether you're approved for unemployment, that's the subject of a whole different webinar for a whole different day. I would contest it and I would seek unemployment as transitional compensation until you find a new job. But whether you get it or not is up to each individual state statutory protection. So I would defer to that. How to file a lawsuit after receiving right to sue letter. You need to contact an attorney or file pro se and determine if moving forward with a lawsuit is a good viable option that you want to proceed with. You can file on your own. TexasLawHelp.com has the pleadings and forms you would need. Otherwise, you want an attorney to do it. Might be best to have an attorney prepare it. But if you you wouldn't want to do your own root canal. You'd want a dentist to perform it. However, could you do your own root canal? Possibly. Could you go on YouTube and figure out how to do it? Maybe. But I think filing your own lawsuit without an attorney is like doing a root canal on your teeth yourself. You really want a dentist to do it, somebody who's qualified and capable. Otherwise, a lot of issues if you do it yourself. You live in Maryland and you have some questions about certain things, I would defer to a Maryland licensed attorney. And the good thing is our team does have Maryland licensed attorneys on staff. So I would recommend you call our number, 518-218-7100. But talk to a Maryland-based attorney who can answer your Maryland-specific questions. I'm sorry, I'm unable to answer that. That would be unlawful practice of law outside my jurisdiction. I'm licensed in Texas and New York and admitted to practice in DC courts, Colorado courts, and other courts around the country, but I'm not admitted in Maryland, so I can't answer that question. My apologies. USERRA Department of Labor process. Talk about that quickly. Department of Labor, VETS. Just Google it. Walks you through what the Department of Labor does when it comes to VETS. It's a Veterans Employment Training Service. Their job is to investigate USERRA claims. I will say Department of Labor is kind of like going to the DMV. Maybe great service, but they probably don't give a crap. And if they don't give a crap, you need to hire a private attorney. Why? Because they're getting paid the same amount of money when they do a good job, or they surf the internet all day. And, human nature, many people would rather just collect a paycheck and take the dog to the vet than call employers and figure out they discriminate. The Department of Labor does an USERRA investigation the way this Saturday Night Live skit would be a IRS auditor who doesn't care about the job. Imagine the IRS calling you up and saying, hey, we were told you didn't pay your taxes correctly. Is it true? And you tell them, well, no, of course you pay my taxes. And then the investigator is saying, oh, well, thank you. I'm really happy to hear you paid your taxes and everything's good. Happy to know that. I'll close the investigation out. We're fine. That's basically what the Department of Labor does to employers. They call the employer and ask, so are you discriminating against this person for military service? The employer says, oh, of course not. And they say, oh, okay, thanks. And they close it out. They don't do much else. They don't actually do a real investigation. It's kind of a joke. It's kind of a Saturday Night Live skit. You need a private attorney who cares to go after private employers when it comes to USERRA. The government may help, but many times they simply won't. And again, they don't have any incentive to help because they're paid whether they do their job or not, which is unfortunate, but that's just the reality of government work. Workplace injuries and whistleblower retaliation. That's really outside the scope of this presentation that's more of a workers' comp type situation, but if it's whistleblower retaliation, you may have a claim, you want to talk to an attorney, you want to consult with us, I would set up an appointment and see if we can help you out, or any other competitor attorney. Wrongful termination. Yes, there's many bases, and that's a great ending question. If you're fired because of your race, your religion, your sexual orientation, that's unlawful. And if that's the reason you were terminated, and you can establish facts to support that claim, that's the why you were targeted for separation, then you have a claim. The point of this presentation was to cover the categories that are unlawful and to help you find the evidence you need to support that. If they fire you for what's called a subterfuge reason, they tell you it's because you were late to work, but you actually weren't late to work, and then you can show that, then you may have been targeted for race or gender or religion or any other protected characteristic. And it becomes a fact in dispute, and it's up to a jury to decide who's telling the truth or not. Hopefully negotiate a resolution before a jury gets involved. And that's really the point of this presentation. So I want to encourage everybody to keep a couple things in mind. Everybody is entitled to be treated at work with dignity and respect. With that in mind, some people have medical ailments, some people have PTSD, some people have, cultural differences. So their behavior might be different than what you would normally expect. If their cultural differences or their PTSD or their medical ailment causes them to act differently, you may not be the victim of harassment or discrimination or unlawful conduct. It may be permissible deviations from standard expected conduct. However, if the behavior gets to a point where it's severe, pervasive, and causes you harm, then it could be unlawful. That's why you should take steps to try to stamp it out. And if you're unable to do so, then you'd want to seek relief, either internally by complying with HR or by seeking the intervention of legal counsel to see if there's remedies available to assist in facilitating you to be treated properly at work with dignity and respect. Everybody deserves dignity and respect, regardless of national origin or which state you were born in or what baseball team you root for. But sometimes things happen at work that cause problems. And if you are the victim of issues, you certainly want to consult with counsel and see if you have a claim, and we're happy to try to help you out. Again, my name is Sean Timmons, and you can reach me at 518-218-7100. You can contact us on our website, tullylegal.com, and we're here to provide guidance and assistance. And last, but just finally, I expressed a ton of opinions in my presentation because I went through a lot of material quickly. The opinions expressed are the opinions of Sean Timmons, attorney at law, Texas bar number 240-67908, and only me, nobody else. So keep that in mind. If you have any feedback, I certainly appreciate it. And I appreciate all the positive online client reviews that I've received over the years. And I appreciate all my clients who've allowed me to represent them in multiple places around the world. Thank you. And with that, I'll close the presentation.